Welcome to The Debate. When structural engineers design a massive suspension bridge, they don't just calculate for the static weight of the cars driving across it.
Right, they have to account for the environment.
Exactly. They calculate for the crosswinds, the sudden seismic shifts, those invisible forces that really test the integrity of the anchor points.
Which is a great analogy for political coalitions, especially in emerging democracies.
Yeah, because in politics, those anchor points aren't made of steel. They are made of, legal structures, party constitutions, and judicial recognition.
And on Thursday, April 30, 2026, the Nigerian Supreme Court basically tested the anchor points of the country's political opposition right to their absolute breaking point.
They really did. In a single afternoon, 2 separate Supreme Court panels delivered these twin judgments that just completely rewire the opposition landscape ahead of the 2027 elections.
It was a monumental day. Just to give our listeners some context, leading up to this, the Nigerian opposition was trying to unify against the current administration, right?
Yeah, they held that massive summit in Ibadan.
Right, bringing together political heavyweights. You had Atiku Abubakar, Peter Obi, Rabiu Kwankwaso, and they hatched what they called a two-party coordination strategy.
Which basically meant they would anchor their movement across 2 platforms, a reformed faction of the traditional powerhouse, the PDP, and a secondary vehicle, the ADC.
A clever plan on paper, but as we're going to discuss, built on incredibly shaky legal ground.
And that brings us to the central question of our discussion today. Do these twin Supreme Court rulings deal a fatal, fracturing blow to the Nigerian opposition coalition?
Or, conversely, do they establish the harsh but entirely necessary legal boundaries required to force this opposition into a single, functional, unified bloc before 2027?
See, I represent the view that these rulings critically dismantle the opposition's structural viability by validating a hostile leadership in one party and, frankly, trapping the other in contradictory legal constraints.
And I take the opposite perspective. I argue that the rulings strip away legally doomed illusions, providing necessary legal clarity and really forcing the opposition to pragmatically consolidate.
Well, let's break down exactly why the structural integrity of this opposition has been compromised. Let's start with the PDP side of the equation.
Okay, let's get into it.
For our listeners who might be losing track of all the moving pieces, the opposition's plan relied heavily on a faction of the PDP led by Turaki.
Right, that was supposed to be the main anchor.
Exactly. But look at what the Supreme Court actually did on Thursday in Appeal No. SCC V16-2026 in a tightly contested 3-2 decision. The court completely voided the November 2025 Ibadan Convention that empowered Turaki,
Legally wiping it off the board.
mathematically and legally decapitating that wing of the opposition. Turaki's leadership just evaporated.
Yeah, it's gone.
But the ripple effect is what makes this so devastating. Because Turaki is out, the court essentially validated the rival faction, the one heavily aligned with FCT Minister Nyesom Wike.
Who, despite being in the PDP, is serving in the current administration.
Right. So now, you have sitting opposition governors, specifically Sabi Makinde of Oyo State, who literally hosted that Unity Summit, and Bala Mohammed of Bauchi State.
They are legally trapped.
Completely trapped inside a party machinery wholly controlled by a pro-administration faction. Now, I know we are going to discuss the ADC's simultaneous reprieve at the Supreme Court.
Which is the other massive half of this story.
Yes, but I want to state up front that reprieve is a mirage. It is just temporary breathing room that is legally insufficient to support the colossal weight of a unified national campaign.
Well, I understand the gravity of the political fallout you're describing, but we have to look honestly at the foundation of what the opposition lost here.
Okay, what do you mean?
A coalition built on a foundation of legal defiance is no coalition at all. It is a massive liability. Let's not forget why the Supreme Court voided that convention.
You're talking about the Omoto Show order?
Exactly. The Turaki-led PDP faction explicitly defied Justice James Omotosho's October 2025 order regarding Sule Lamido's exclusion. You cannot build a serious national political strategy while openly flouting a direct court injunction.
That's fair, but
The Supreme Court, via Justice Stephen Adana's lead majority judgment, didn't destroy anything. They simply applied the rule of law. But if we want to talk about structural victories, the true win for the opposition happened in the unanimous ADC ruling.
You mean appeal number SCCV 1802-026?
Right. The lower court of appeal had issued a deeply flawed order that basically froze the ADC's leadership, leaving them totally paralyzed. The Supreme Court recognized that as a massive jurisdictional overreach and unanimously slapped it down.
They did vacate that order, yes.
And in doing so, it forces INEC to legally recognize David Mark's leadership of the ADC. The judiciary just handed Atiku, Obi, and Kwankwaso the exact, legally unencumbered vehicle they need to operate.
Completely free from the compromised machinery of the PDP.
Exactly. Free and clear.
Let's hold on the ADC for a moment, because that brings us squarely to the tension between strict legal adherence and on-the-ground political reality within the PDP.
Sure.
Immediately after the judgment, Nyesom White came out, took a victory lap, and declared that factions no longer exist in the PDP.
He certainly did.
He framed the rival March 29, 2026 Abuja Convention, the one that produced Abdulrahman Mohammed and Samuel Anua, as the sole, unassailable, legitimate structure.
I'm sorry, but I just don't buy that. Let me tell you why Waiki is absolutely legally correct here, even if the politics are incredibly messy.
Legally correct that factions don't exist?
Yes. The Supreme Court has spoken, and it has settled the leadership matter conclusively. The Ibadan Convention is void. The Abuja Convention stands.
But it was a 3-2 split. It wasn't unanimous.
I know, but to me that doesn't delegitimize the ruling. It merely highlights the deep, ongoing jurisprudential complexity regarding justiciability in internal party matters.
Justiciability meaning whether judges should even intervene in party politics?
Exactly. It shows that the boundaries of judicial intervention are fiercely debated even by the highest court in the land. But at the end of the day, a 3-2 decision is still a final decision.
I suppose that's technically true.
The finality of this ruling effectively cauterizes a wounded limb of the opposition. Waike's faction is the PDP now. That is the legal reality. And in a Nigerian electoral cycle governed strictly by the Electoral Act, legal reality is the only reality that actually gets your name on the ballot.
I see why you think that, but let me give you a different perspective on what actually constitutes a political party.
Go ahead.
A party isn't just a piece of paper validated by a gavel. It is a living, breathing organism made up of human capital, physical state structures, and massive voting blocks.
Nobody is denying that human capital is important.
But when Waike claims that factions no longer exist, he is exposing a massive, unbridgeable gap between judicial outcomes and political realities. Let's break down the mechanics of this.
Okay.
How can a political party possibly be considered unified when its two most active state leaders, sitting governors, Makinde and Mohammed, are deeply, fundamentally opposed to this national leadership?
Well, they might be opposed.
They consider this National Working Committee to be invalid, in spirit, if not in law. And let's explain how this traps them.
By all means.
In Nigerian politics, the National Working Committee, the NWC, holds the administrative keys. If you want to run for office, the NWC has to sign your nomination forms and submit them to INEC.
That is standard procedure, yes.
If they don't sign, you don't exist. So the court didn't just issue a ruling. They effectively changed the locks on the PDP headquarters while the opposition governors were still inside.
Oh, that's a bit dramatic.
You have a situation where the legal leadership of the party is actively hostile to its most prominent elected executives. That isn't resolving a crisis. That is legally mandating an internal civil war just months before a general election.
But see, it actually forces a resolution to that civil war rather than letting a low-grade insurgency simmer into the election year.
By forcing them to surrender?
By handing the keys definitively to one side, it forces the losing side to make a concrete decision. But we really cannot look at the PDP in isolation here.
You want to bring it back to the ADC?
I do, because the opposition's survival, their whole backup plan, relies heavily on that ADC ruling, which, unlike the PDP case, was a unanimous decision and arguably much more consequential for the 2027 race.
Well, let's transition to that ADC lifeboat then, because this is where your argument about legal clarity really gets tested.
I'm ready for it.
The Supreme Court vacates the appeals court's freeze order. Excellent. INEC has to recognize David Mark. Fantastic. But look at the landscape they're walking into.
It's a much better landscape than they had yesterday.
It's like being handed the keys to a getaway car, but another judge has simultaneously clamped all 4 tires.
Clamped the tires? How so?
Just one day prior to this Supreme Court ruling, on Wednesday, a judge at the Federal High Court, Justice Abdulmalik, delivered an independent ruling, suit number FHC ABJS 581-2026.
Ah, the state Congress's ruling?
Yes. She explicitly barred interim or caretaker committees, exactly like the one David Mark is running, from conducting state congresses. She cited both the Constitution and the ADC's internal rules.
Right, but...
And why does this matter? Because a state Congress is how you pick the delegates who vote in your presidential primaries.
Yes, that is the mechanism.
The Supreme Court on Thursday did not address this Wednesday ruling. They operate in parallel. So David Mark has his title restored, yes, but his committee is legally restrained from executing the basic fundamental functions necessary to prepare for an election.
I hear what you're saying.
How can the ADC realistically meet the incredibly tight May 30 primary deadline under these conflicting, overlapping constraints? They are paralyzed before they even start the engine.
That's a compelling argument. But have you considered the fundamental difference in the nature of these two legal hurdles?
They both stop the party from functioning.
Not in the same way. What the Court of Appeal did, which the Supreme Court unanimously slapped down, was an existential threat.
The status quo order.
Yes. Let me explain what happened there. The appeal court dismissed David Mark's case on a technicality, but then turned around and issued a status quo antebellum order.
Essentially hitting the pause button.
Exactly. Freezing everything exactly as it was before this legal fight started. As the Supreme Court panel rightly noted, that is a blatant jurisdictional overreach.
Because they claimed they didn't have jurisdiction but issued an order anyway.
Precisely. You cannot claim you lack the jurisdiction to hear a case and then issue binding preservative orders on that exact same case.
Right. Okay.
So, by removing that unconstitutional block, the Supreme Court immediately stripped INEC of its legal justification for derecognizing Mark. That is the crucial pivot point.
But what about Justice Abdulmalik's ruling?
Regarding the lower court's constraints on state congresses, yes, it is absolutely a hurdle. But it is a procedural hurdle, not an existential one.
Procedural? It stops their primaries.
The immediate burning priority for the ADC is not the May 30 primary deadline. It is the May 10 deadline to submit their membership register to INEC.
Okay, true. That is the first deadline.
Mark now has the legal authority to walk into INEC headquarters and submit that register. Navigating the internal constitutionality of how state congresses are formed, that can be managed.
Managed how?
Through alternative delegate arrangements, consensus building, or rapid legal appeals. But you cannot even get in the room with the Electoral Commission without the Supreme Court lifting that initial derecognition.
I'm not convinced by that line of reasoning, because you are treating the Federal High Court as if it's just a minor inconvenience, a speed bump.
It's certainly manageable compared to derecognition.
In reality, it is the very venue that holds the ADC's ultimate fate. You call it procedural hurdle, but let's look at the long-term instability embedded in this very Supreme Court judgment.
The Supreme Court judgment is final.
Final on the appeal court's jurisdiction, yes, but the Supreme Court didn't actually declare David Mark the substantive, permanent, undisputed chairman of the ADC.
Well, they sent it back down.
Exactly. They merely took the original leadership dispute and sent it back to the Federal High Court for an expedited hearing before a different judge, Justice Emeka Nwite.
Right, for the substantive hearing.
So what does that mean mechanically? It means every single action the David Mark leadership takes right now, from submitting that May 10 register to organizing those primaries, operates under a massive, dark cloud of potential reversal.
I wouldn't call it a dark cloud.
If Justice Nwite eventually rules against them, everything they've built collapses. And we haven't even touched on the unresolved external factions.
You mean the Kachiku group?
Yes. The Kachiku-aligned caretaker group hasn't dissolved. The Bala Abejid faction remains an active, vocal threat, vowing to fight this to the finish.
Those are just splinter groups, really.
But you are asking Atiku
Obi, and Kwankwaso to place their entire political future into a vehicle that is currently being sued by 3 different factions and is actively awaiting a trial court's substantive judgment.
I come at it from a different way. If you step back from the procedural weeds and look at the macro picture, what actually happened on this single Thursday afternoon was a radical, incredibly necessary simplification of the Nigerian opposition map.
Simplification? It sounds like chaos to me.
Yes, there is pending litigation. When is there not pending litigation in Nigerian pre-election politics? It's practically an Olympic sport.
Fair point.
But let's look at what is definitively, unequivocally gone. The Turaki PDP is judicially finished. It is over.
True.
The complex, overly clever two-party coordination strategy where the opposition tried to keep a foot in the PDP and a foot in the ADC has been dismantled by the courts.
I agree with that.
And frankly, it needed to be. Governor Say Makinde and Bala Mohammed now face a stark binary choice.
Which is?
They either submit entirely to a white-controlled PDP, which is politically suicidal for their national ambitions, because it means surrendering to the administration's proxy, or they defect.
And move to the ADC.
Exactly. And if they defect, they take their massive state structures, their grassroots organizers, and their resources over to the ADC.
You make it sound so simple.
This harsh legal reality forces the exact unified candidacy the Abidan Declaration promised, but failed to actually implement. It abandons the complicated two-party strategy for a single, viable ADC platform.
By burning down their other option.
Precisely. It forces Atiku, Obi, Kwankwaso, and the governors into the exact same room under the exact same roof, because the courts have quite literally burned the other house down.
But that grand theory assumes the ADC roof isn't leaking, which, as we just established with the pending litigation and the restrictions on state congresses, it absolutely is.
Every political roof leaks a little.
If Governor Makinde and Governor Mohammed defect to the ADC, they aren't escaping legal chaos. They are just trading the closed, finalized legal trap of the PDP for the open, active, chaotic legal minefield of the ADC.
I disagree that it's a minefield.
Furthermore, you make it sound like taking state structures from one party to another is just a simple copy and paste exercise. It is not.
It happens all the time in Nigerian politics.
But the Wike-aligned national leadership is now heavily empowered to install their own loyalists in Oyo and Bauchi states, using the full force of INEC recognition.
That assumes the governors leave anything behind.
The state governors might leave, but the party machinery stays behind. The courts haven't simplified the map, they have fractured the opposition's resources.
I wouldn't go that far.
They are now forcing these politicians to spend millions fighting defensive legal battles on multiple fronts instead of organizing a cohesive grassroots campaign against the administration.
Look, defensive legal battles are exactly what the Supreme Court just rescued the ADC from, by striking down the appeal court's overreach.
For now.
You have to remember the context. Just 24 hours prior to this ruling, INEC was refusing to even open correspondence from the David Mark leadership.
Right, because of the appellate order.
The administrative strangulation was absolute. The Supreme Court broke that by establishing clear legal boundaries, voiding conventions that openly defy injunctions, and striking down appellate courts that blatantly overstep their jurisdiction. The judiciary is doing the regulatory work the political parties refuse to do themselves.
But is that the judiciary's job?
It is enforcing discipline in a system that desperately needs it. Look, if Makinde, Mohammed, Atiku, and Obi cannot figure out how to put their egos aside and operate within the legally recognized framework of the ADC between now and the end of May, then they lack the organizational competence to challenge the incumbent administration anyway.
Wow.
The court has cleared the board. It's up to the politicians to play the pieces.
It is a profound risk to equate judicial discipline with political viability. We are looking at an opposition coalition that woke up on Thursday morning believing they had a multi-pronged, robust institutional strategy.
A flawed strategy.
But a strategy nonetheless. And by Thursday evening, they found themselves with one judicially voided faction and one temporarily reprieved faction
operating under severe lower court injunctions.
Which brings us to the broader implications.
Exactly, as we synthesize the events of this defining Thursday. To summarize my position, the April 30 judgments leave the opposition deeply, perhaps irreparably fractured.
And I still see it as a necessary pruning.
Well, they have lost their institutional influence in the PDP to a politically hostile, administration-aligned leadership. At the same time, they are now entirely reliant on an ADC structure that is only temporarily protected by the Supreme Court, heavily restricted by active federal high court rulings, and awaiting a final substantive trial.
And that's your summary.
Yes. The structural anchors of the Ibadan coalition have, in my view, fundamentally given way.
And to summarize my perspective, these rulings represent a triumph of necessary legal boundaries over political wishful thinking.
Wishful thinking, huh?
Absolutely. By legally terminating the doomed, structurally flawed PDP faction and strictly correcting a massive judicial overreach that was suffocating the ADC, the Supreme Court has stripped away the distracting illusion of a two-party strategy.
Leaving them with just one option.
Exactly. They have provided the opposition with the singular, focused, legally unencumbered path it desperately needs to pragmatically consolidate and actually prepare for 2027.
What we can certainly both agree on, looking at the mechanics of these rulings, is that the 3-2 split in the PDP case proves that the boundaries of judicial intervention in party politics remain highly contentious.
Unquestionably, the philosophy of justiciability, when and how a judge should intervene in party affairs, is far from settled, even among the most senior legal minds in the country.
It really is.
It's an evolving area of law, and the true test of these rulings won't just be found in the written text of the judgments.
No, it'll be in the actions.
Right. It's going to be in the immediate actions taken by INEC regarding that looming May 10 deadline, and the very real human political calculations made by figures like Governors Makinde and Bala Mohammed in the coming days.
Precisely. It highlights the immense value of looking at judicial pronouncements not just as legal finalities, but as massive catalysts for political realignment.
Very well said.
In emerging democracies, the courts don't just interpret politics, sometimes they inadvertently design it. We highly suggest listeners continue to explore how these unresolved cases evolved before Justices Nwite and Abdulmalik.
Because the legal choreography of this election cycle is far from over.
It certainly is. As we close, we leave you to decide. Has the opposition been fatally wounded or just pragmatically streamlined? Remember, when you build a bridge, the crosswinds don't care about the beauty of your blueprints.
They only test the strength of your anchor points.